Hello and welcome to the second episode of our podcast, Life in Law. I'm Michael Ives, Legal Recruitment Specialist on behalf of ACON. And with me today we have George Pollitt. George is a Tier 1 ranked employment law barrister. George comes with a highly credible background, having qualified as a solicitor and a barrister after being called to the bar in 2009. Thank you for joining me. How's it going?
I'm well, thank you. Thank you for having me.
Great stuff. So I know that you obviously qualified as a solicitor and a barrister. So what made you take that route?
So I originally wanted to be a barrister. I did the BVC in Cardiff and I was called to the bar in 2009. But after about a year or 2 years of applying for pupilages and not being successful, at the time you could take a route, a qualified lawyer's transfer test to change from the barrister route into the solicitor route. You had to do the equivalent of a training contract, but it wasn't a formal training contract. You just needed to have 2 years worth of experience and pass an exam. So all the bits that we missed on the bar vocational course, such as handling client money and things like that, you had to take an exam to deal with that side of things. But if you did that and you did your 2 years training contract or equivalent of a training contract, you could cross qualify to become a solicitor. And after 2 years of interviews and sort of seeing that I was told a couple of times, look, you've come second place, but you've lost out to this guy who's got, a first from Cambridge or whatever, and I don't have a first from Cambridge, and that's nothing I could ever change. I decided, well, look, better to get qualified, do that, get in, see how the solicitor route goes, and then if I want to, you can always change back, because once you're qualified as one or the other, it's much, much easier to chop and change between the two. So after I qualified as a solicitor in 2012, and I spent 3.5 years working for various places. I worked for Das Law, I worked for a employment law consultancy, and then I worked for what was Leo Absey and Cohen Solicitors in Cardiff. And I really, really liked working there, but I was always it always felt like I was doing the substitute. I still preferred being in court, and I was lucky enough that I sort of conducted my own tribunal hearings, and that's when I really felt I was enjoying the job. And then when Slater and Gordon bought Leo Absey and Cohen, I thought, well, look, this is now the push. I was very, very comfortable at Leo Absey and Cohen. Slater and Gordon made a lot of changes, which is understandable. They were a very different firm. They were a much, much bigger firm. And that for me just felt, right, this is the time now to look to go back to the bar. And I did that in December 2015. I had done my higher rights as a solicitor, which meant that you could chop and change between the two professions relatively easily without having to do a pupillage. So I then went to go and work for Clerksroom, or became counsel at Clerksroom Chambers. And I was there for a year and a bit. And then I joined Discoid Chambers in March 2017.
Okay, and because obviously solicitors can act in sort of tribunals, can't they?
They can, yes. And as I say, I did my high rights anyway, so in theory I could have done a multi-track claim in the county court, which a solicitor ordinarily wouldn't be allowed to do. But the problem that I was finding was that I felt like I was doing both things not as well as I should be doing. So when I was doing my solicitor work, I was constantly scrabbling for time, because I spent a lot of time in the tribunal actually representing my clients, which meant I wasn't in the office doing the paperwork, the prep, taking witness statements, that type of thing. And then when I was in the tribunal being an advocate, I wasn't as good as my opponents, because of course they were doing it day in, day out. They tended to be doing it day in, day out. And I was doing it once or twice a month. So I sort of felt like I was a jack of all trades and the master of none. And that really is, the key difference between the two, in my opinion. The lines are much, much blurred now. I'm a barrister, but I have public access accreditation and I can conduct litigation because I've done that extra training. When I was a solicitor, I had higher rights of audience. So the lines were very, very much blurred, but it's about how much time you can actually spend doing the various things. So again, when I was a solicitor, a lot of that work is prep work. It is drafting claims, it's speaking to clients, it's taking witness statements, it's looking at evidence and giving them advice. And that all takes time. And that is a full-time job in of itself. When I'm off to tribunal arguing cases, well, that takes time to prep. And it's just finding the time to do all of these things well. And you can do it, and I did it to a decent standard whilst I was doing it, but I was not as good as I could have been. That's how I felt. And really my heart wasn't in the solicitor job, because I'd always wanted to be barrister, I wanted to be in court. That's where I was happiest. And now that I am counsel, as I say, I do have public access accreditation. I do the odd public access case, but I've much reduced the type of case that I will take on. I will now be very slow to take on a case where I'm actually acting for the client day in, day out as the litigator, if you like. I did that when I started my barrister career because I had so much more time as I was building my practice. But now I'm busier, I would struggle to do that. And again, it's just about doing what you enjoy, really, and taking a step back from time to think, well, what is it? You know, why am I not as happy perhaps being a solicitor as a barrister? What is it that I enjoy about the job? What is it I don't enjoy about it? And you've just got to sort of look at yourself and reflect upon that and just go for the option that suits you best.
And you do a lot of work with Cavendish Law, is that right?
I do a lot of work with Cavendish, yes. I don't work for them, they just instruct me as counsel. Prior to that, I worked as an HR consultant for a company called Lloyd's Law, and then prior to that, as I say, it was Lewis & Cohen / Slater & Gordon.
So in terms of using a barrister at tribunal, do you think that's probably slightly preferable to using a solicitor in that situation?
I think so, yes. I mean, as I say, I've done it, so I'm not saying this to slate solicitors over barristers or whatever. You are perfectly capable, if you are a solicitor, of running your own case. You are. And that includes representing your client at tribunal, but they are different skill sets. Advocacy is a particular skill set, and it requires honing, it requires practice. And it's, you know, it's like being in different positions in a football team. You know, you might be an excellent footballer, but you might not be a very good goalkeeper, for example. You know, you might be good at scoring the goals rather than saving them, and it's a different skill set, even though it's largely the same game. So it just depends on your mindset and your skill set. But yes, from what I always found the issue was the time. As counsel, my job is to represent people in tribunals or courts or whatever. And I have the time to do that because I make time to do that. Whereas when I was a solicitor, there was always the onus, right, you've got to bill X amount of hours per day, and you can't always bill the same amount of time for preparing a case, because the client will say, well, hang on a second, you've charged me 8 hours for being in the tribunal that day, and you've charged me 8 hours of prep, a day's prep. Whereas if I had used counsel, they would have charged a fixed fee, and that would have been the equivalent of one or the other. So you either take it on the chin and say, okay, well, I'm going to charge you the same as counsel would do, but then you're losing out on prep. So it's just time constraints, but it is practice. It's about honing your skills over one or the other. And that's what I think the real difference is between the two, is how much time each one can allocate to different things.
Interesting. Well, one other thing I was hoping to cover with you is something the layperson might not be aware of, is the fact that most barristers are generally self-employed. I just want to find out more about that arrangement from you and how it works.
Well, it's an unusual setup because it tends to be that self-employed barristers are members of chambers.
Yeah.
And chambers is almost like a collective marketing, if you like, in that I am a member of ISCOID Chambers and I trade under that banner, if you like, but I am a self-employed person. We have civil teams within chambers, and we all try and work together to put forward the best image of chambers possible, and we will help each other within chambers. But quite often, the person who I'm giving some ad hoc advice about an issue on Monday might be my opponent on Tuesday. So it's an unusual setup from that point of view. But I have to say, I quite like being self-employed. You are obviously therefore your own boss. There are the pitfalls of that. I remember the week I handed in my notice at what was Slater & Gordon at the time, to leave a nice salaried solicitor job. At the end of that week, I found out that my lovely wife Hannah was pregnant. So I did think, was this really the best time to be going self-employed and giving up that nice wage to not know what I'm going to earn from week to week? And you do have that sort of general anxiety every week. Oh, I didn't bill very much this week. Why am I quiet? That type of thing. You can't really win as counsel sometimes, because if you're either too busy and you haven't got the time to do anything and you're stressed because of that, or you're not busy and you're wondering, well, why am I not busy and my roommate in chambers is, or what have you. But generally, I much prefer it. You have peaks and troughs. There have days and perhaps weeks where you feel, well, God, I've had to work until 2 or 3 o'clock in the morning almost every day this last few weeks just to get on top. But then you'll have days where you go into court, you have a relatively short hearing, that lasts an hour or half an hour, and then you're done. And that might, if you're very lucky, be on a Friday or something like that, and you can go off and do what you want to do. And a lot of the job is travelling as well, because I represent people all over England and Wales, and so I have to often get up very early, get on the train or drive or what have you, and that's part of the job as well. And there are long days with it, like any self-employed person. But I think the pros of having the control over your practice and the ability to decide your own future to some extent outweighs the negatives of the insecurity of knowing what you're doing from day to day.
And like in terms of your sort of clients you pick up and work with, is it the chambers who deal with that, or do you do it yourself?
It's a mix of both. So again, it's a strange setup, because sometimes what will happen is a solicitor will pick up the phone to a chambers that they use quite regularly and say, I need somebody to represent my client at again, I use an employment tribunal as an example, an employment tribunal claim in Cardiff or Swansea on this date. Do you have anyone? And then the clerks will put forward 3 or 4 suitable people if they're free on that day. And they'll say, well, this is Mr. Pollitt and he's 2009 call, or you can have somebody more senior like David Harris, who's several more years call than myself. Or at the other end of the spectrum, there's a pupil that we've got and he'll cost this much, for example, and generally you'll sort of put forward a price bracket. And in those situations, again, it's unusual, because even though we're all in the same chambers, to some extent we're competing for the same work. Do I get the job and therefore get the money, or does David Harris or whoever? And that can be sort of unusual, and again, that's the unusual setup of chambers. But what you really want to do when you build your barrister practice is to avoid all of that by building a relationship with a solicitor who will pick up the phone and say, I want George Pollitt to represent my client at X. And if they do that, then that takes out the sort of internal competition within chambers, because solicitors are perfectly entitled to ask for me by name if I've done a good job for them in the past. Yeah. So that's really the sort of the ongoing marketing of counsel, is to keep their professional clients, solicitors usually, happy, and make sure that even if maybe you lost the case that you last represented for them, that you did a good job. And that usually means keeping the lay client happy. And lay clients will be first in line to say, well, look, I don't think Mr. Pollitt did a very good job for me, or even though we lost, I still think he did a good job for me, or what have you. It's not always about results. It's sometimes about how you handled the case, how you handled the litigation, and how you made the client feel at various times. So yes, it's that sort of ongoing internal marketing. Now with public access, it can be that people email chambers and say, do you have somebody who can advise me directly? And that's slightly new and different, but certainly for our chambers. And then we just deal with that internally. We've only got a few people who do public access, so that's where you don't have a solicitor and members of the public can go straight to counsel and seek advice. There are slight differences in what barristers can do and what solicitors can do. We can't handle client money, for example, as a barrister. We wouldn't be the best people to handle a conveyancing for that reason. And in reality, I don't think there's many barristers that would want to do that type of thing, but I might be wrong. Because in essence, what the client would have to do is have to sort their own funds and things like that, which is difficult. But no, generally speaking, it is somebody calling up chambers, speaking to the clerks, and either asking for me or asking for somebody like me.
Okay, and what would you say your kind of average day-to-day would look like?
Well, it's one of these sort of sayings, but no day is the same as the next in this job, because every case is different. So an average day for me, if I'm going to court, will be getting up, grabbing my brief, wig and gown if I need that, which is quite rare in civil law, as you may or may not know. And then getting on the train or getting in the car and getting to the court, meeting the client at about 9 o'clock when the court opens, having your hearing start at 10, and then it depends on what the hearing is as to whether that lasts all day or whether it finishes. But again, if you're only doing a short hearing, you might not have anything until, say, 3 o'clock. So you might get up, you might do some paperwork in the morning, and then go to court and repeat that process, but at just different times. You finish your hearing, you then have to write an attendance note, which I just do via email to say, right, okay, to the solicitor, this is what happened at court today, because it's quite rare actually for solicitors to be behind counsel in most cases because of the cost. It would have to be a very high value claim in order for that to be cost effective. So you need to write a really detailed attendance note so that solicitors know, well, this is why we won or why we lost, or this is the issue that arose, and this is how I need to deal with it as a solicitor, because of course they weren't there to know. And at the end of the day, after I've done my bit, the case passes back to the solicitor. So of course they need to be the ones in the know to know what they've got to do next. But if I haven't got a hearing, then I tend to get up. I would probably drive to Chambers. I live in Cardiff, but my Chambers is in Swansea. And I would do a papers day there. I've just finished my first bout of being a pupil supervisor, so I might make sure that my pupil was busy and had something to do, or review their work, or it's just doing paperwork, so drafting, which is what I'm doing at the moment quite a lot, as you can imagine, because the courts are largely closed. Doing a lot of drafting, so that might be advising people about whether they have a good or a bad claim, or the value of a claim if they've suffered an injury or loss, or this afternoon I've been drafting a defence to a claim and things like that. So that's quite a large part of my practice as a civil lawyer. A criminal lawyer would do much, much less of that, and they would tend to be in court most days, maybe a couple of times a day, whereas civil lawyers tend to be more balanced between drafting and advocacy.
So do you do much preparation when you go to trial, or would you work quite closely off the brief the solicitor's given you?
You need to do your own prep, and every case is different. I mean, sometimes you'll get a case and it's a 20-minute application hearing, and it's very, very straightforward. Like, for example, in a civil claim in the county court, I don't know, somebody's filed a witness statement late, for example, and you have to apply for relief from sanctions, and that's a relatively straightforward process. You go to the court, you say to the judge, look, claimant or their solicitor is very, very sorry, but they filed the witness statement late because, I don't know, the file handler was sick or something like that. And there's a discussion about prejudice and things of that nature, and you go through the test, and that's that. And that you could prep within sort of half an hour, depending on the number of papers in the case. But equally, I had one the other day, which was a 3-week-long case in which there were 3 lever arch files of evidence. And in that case, I had to set aside several days of reading, and I had a few conferences with the client before that. So every case is different. But yes, you need to know your case inside out. And it's, again, part of the skill set of counsel is being able to absorb that information relatively last minute a lot of the time, and being able to relay that in a positive way to build your case. And you need to know the case inside and out to be able to cross-examine somebody, because you have to know the answers of the questions before you ask them, really, in order to sort of trap people into saying what you want them to say. But you have to do that, absorb all of that, and then you need to almost eject all of that knowledge so that you've got space in your head for the next case, the next step, turnaround of picking up information, retaining it for a relatively short period of time, and then moving on to the next one.
And in regards to students in maybe the LLB or the LPC doing an advocacy module, what basic advocacy advice could you give them?
It's keep it simple, I suppose, is the easiest thing to say. A lot of people feel because they're in court, or they're pretending to be in court, that they have to use jargon and ask really stupidly complicated questions for quite a simple situation. I was at some advocacy training the other day, and somebody suggested, it was a question about an incident that happened at football training. And the question that the advocate put was something along the lines of, so how often does your son partake in the training of the football activity? And there's so many words in that. And really what he was saying is, well, how often does your son train for football? You know, it's as simple as that. Just use the simple language, because it just helps everybody. You know, it's not a sign of your intelligence to just add extra words in there for no good reason whatsoever. Keep it simple, keep it plain, and generally keep it slow. And I'm quite guilty of speaking quite quickly, even now after years of practicing. I have to remind myself to sort of slow it down so that people can pick up notes. But if you slow yourself down, it gives you time to think, but also whoever is, if it's an advocacy exercise, scoring you, but in real world, the judge, it has to take notes. And they need to have time to digest what you're saying, to take the notes and actually understand the answers that are given. But pace is a really, really big thing.
And isn't there a tendency for individuals to maybe go in for the big gotcha question too quickly and get a bit too excited?
Yes, absolutely. So, and that really is the skill set, is knowing when to ask your question key question. And they use all sorts of different analogies for this, is sort of shutting the door behind them as you go along. But in real terms, what you're doing is you're asking a series of seemingly unimportant questions which lead up to the trigger question, the important one. So, and ideally, if you're cross-examining, you'll be leading. So you'll be saying, it's right, isn't it? Yes or no answer type questions, and getting them to say yes most of the time, because you want them to agree with you. What I would suggest to people is don't go in too aggressive at all. It's cross-examination, but the bad pun is it shouldn't be done in a cross way. If anything, you should be the smiling assassin. You should be very pleasant, very friendly, get the witness to almost like you and go, yeah, I want to agree with what this guy is saying because he seems to understand my point of view, even though actually my job is to prove the opposite. And ask them a series of seemingly unimportant questions in order to get to the point where they look unreasonable. So thinking off the hoof, say somebody says that they left work, walked a certain distance and then witnessed an event. Say that's the example. Then you might ask them, well, what time did you finish work? 10:30. And where is your work? It's on this street. And how far away is that from the place where you saw the incident? Oh, it's about 5 miles. Okay. And you were walking? Yes. You weren't running? You weren't in a rush? No, nothing like that. And you left work at 10:30? Yes. You say you saw the incident at 10:45? Yes. Well, that can't be right, can it? Because ultimately, you can't have walked 5 miles in 15 minutes, something like that. So you've set up a series of seemingly unimportant questions by asking basic factual things. Ideally, again, you know the answer to all these things before you ask it. And then you undermine their evidence, and they might come up with some excuse then, oh, well, actually, no, I was running, or I got on a bike, or something like that. But of course, because you've asked them all the unimportant questions, or seemingly unimportant questions, like you were walking, you weren't in a rush, that then undermines the answer that they've given previously, and it casts doubt on their evidence. So it's that type of thing. Okay,
so yeah, just slowly peeling away at them until you get the answer you want, I suppose.
That's it, and then resetting. So you've done that, you've made your point, but don't make a big song and dance about it, because you probably need to move on to another area and do the same thing again. So if you go into aggressive at that point, where say you can't have seen this, then they're going to put the walls up and start being defensive. So you need to get them back on side again. So it's just repeating that process time and time again. But again, that's only possible if you know your case well, and if you know the pages in the documents well. So have a look at page 57. This is where you said this in an email previously. That undermines what you're now telling this court, doesn't it? That type of thing. You have to know the facts in order to test people on their knowledge of it.
Sounds like a big part of this is just staying calm, to be honest with you.
Yeah, absolutely, and it's so easy to get involved with it as well. You get your blood up, and you know, if you're like me, you quite enjoy cross-examining, and you think, oh yes, I've got this guy. He's just said, you know, the absolute, he's sunk his own ship sort of thing. But you can't let the game as poker face, I suppose. It's keeping your cards close to your chest until you need to show them.
Brilliant. Well, I was hoping to move on to find out how you kind of secured your pupillage and where you did it. So where did you do your pupillage?
Well, I didn't. As I said, I had an unusual route to the bar in that I did the bar course, and then after several pupillage interviews, I decided to cross-qualify to become a solicitor. So having done that, what I did is I worked at various places in order to qualify as a solicitor. So I worked at Das Law, I worked at this HR consultancy, and then having done the requisite 2 years, I could apply to become a solicitor, which I did, and then I joined Leo Absey & Cohen. I then got my higher rights as a solicitor and worked for Leo Absey & Cohen, and then later Slater & Gordon for about 3.5 years, something like that. And then I could apply to become a barrister, a qualified barrister, and without having to do a pupillage. It's slightly different if you do the solicitor route, get your higher rights immediately, and then apply to become a barrister. The BSB or the Bar Council might say, no, you still need to do a pupillage because you're still relatively inexperienced and you haven't got much advocacy in your history. Whereas because I'd been in and out of tribunals for several years by that point, I was able to waive that element of it. So then it was just a question of applying for tenancy, and I went to Clerksham Chambers, which is they're based down in Taunton, but the idea is that all of the barristers work from home as their individual bases. So they have barristers all over England and Wales, rather than the sort of traditional chambers where everybody goes to a physical building like my current chambers in Swansea. And the idea is that they can cover all of England and Wales courts. So they were great, that was great to set up. But because I was still relatively junior, I felt I had to expand my practice a bit. I was limiting myself just to employment law and to some lower level personal injury work. And at the time, they had introduced fees into employment tribunals, so the employment tribunal work was quite limited. And so I actually had a sort of tap on the shoulder from a member of Iscoy Chambers who said they were looking for a civil lawyer, and they asked me to apply for tenancy, and that's what I did, and I got in, and I've been there since March 2017.
Okay, and did you say before that you have your own pupil or pupils?
I did, yeah. I had a chap called Dominic. He's actually just finished last week. So yes, I've been supervising him for the last 6 months now, his second 6, which sadly was sort of interrupted by the virus, but he was able to get on his feet for several months before that. That unfortunately put the brakes on things, but we managed to set him sort of written work and be able to assess that.
Did he apply directly to you? Did you interview him, or?
No, at the time I wasn't on the pupillage committee. I've only recently done the training in order to be a pupil supervisor, and actually they've made quite big changes as to who can be a pupil supervisor. There used to be a sort of set criterion of how many years practice you had to have, and you had to do training at the Inns of Court. Nowadays what they say is, well, look, it's up to chambers to determine who is suitable to be a pupil supervisor. Ultimately they have to sort of follow their common sense as to who has got enough experience and enough time in order to be a pupil supervisor. So no, Dominic was selected before I was sort of involved.
Okay, and what advice would you give to an individual looking to apply for a pupillage? How do they make their application stand out?
Yes, well, I mean, it's probably a bit rich coming from me because, as I say, I didn't actually get a pupillage. So, but on the other side of things, what I would say, and having done many interviews, and other than pupillage interviews, they went pretty well, is that you've got to somehow make yourself stand out to some extent. I mean, before we even get to an interview, what I would say is your CV or your cover letter, or whatever, shouldn't be hugely long. Most chambers, even our chambers, and we're not a huge chambers, will get hundreds of applicants for 1 or 2 pupillages a year, and there's only 3 or 4 people that read them, and we sort of divvy them out and go from there. So you can imagine that the people reading these CVs or these applications aren't spending hours poring through meticulous details. So ideally your CV is only going to be a couple of pages long with a covering letter or something like that. Just, and I'm sure most of the people listening to this have heard this before, but just nice, short, concise summary of what you've been doing. Obviously having good grades is important, but experience is equally important. Get out there, try things like I was volunteering at the CAB when I was doing my undergraduate, for example. That meant that I had actual practical experience of the law. I was lucky enough that I could represent people in housing possession matters. I was part of the sort of shelter volunteers there. And again, that was actual in-court experience as well as advising people face to face. So that's the type of thing is really important as well. Get out there, and if you want to do the pupillage route, do mini pupillages, or you want to do the training contract route, get out there and do some work experience with people. Different chambers and different firms do that differently as to whether you can do that informally or formally, if there's a set process, etc. But just fill up that CV with as much relevant experience as you can. And in terms of the interview, I was interviewed by a number of different chambers, and they all had different approaches. Some of them were quite deliberately almost abrasive in the interview process, and the idea of that, I subsequently have learned, is to see how people cope under pressure when you've got that unruly judge who just isn't listening to you and is making seemingly ridiculous decisions and arguing over you and what have you. How do you cope with that? And that you can't necessarily see on the CV, because you might be academically brilliant, but there are different skill sets needed to be counsel. You need to be able to stand up for yourself, but be respectful and not lose your cool. So some chambers will do that, and if that happens, just see that for what it is, because these people are probably playing a role. They're not like that. They are deliberately trying to knock you off your perch, if you like. So just see it for what it is and play the game by keeping cool, answering the question as best you can. Others is just a series of questions and answers, as you would expect, about your CV. That gives you the opportunity to really sing about yourself and say, well, I'm great because X, Y, and Z. In those circumstances, you've almost got free reign to do it. Prep for the sort of daft questions that sometimes people ask. There was, you're in a hot air balloon with persons A, B, and C. Who do you chuck out of the balloon and why? Almost impossible questions. It doesn't really matter what answer you give. It's just about how you argue it. It's about, well, why do you justify chucking so-and-so out of the balloon? It's an impossible situation. You've got to chuck somebody out of the balloon, and you know that they're going to die. But you have to somehow argue the case, and that's what the job is. Sometimes you're arguing cases which you don't personally believe in, and you wouldn't personally do, but that's not the point. The point is that you have to be able to put forward arguments for things. So just preparing yourself for things like that. Tricky questions like, what are your biggest weaknesses? That will come up quite often. And that's supposed to show sort of insight into yourself and whether again you can handle that sort of question, because it is tricky, but everybody has a weakness and it's how you deal with it. So for example, I used to say, well, I'm a worrier. I worry about cases and I worry about things like interviews and stuff like that. And that can, if you let it, become a problem because you worry too much and you don't perform. But then instantly turn that around into a positive by saying, but I have learned to control that by using that positive energy into research or whatever, something like that. So you turn the negative into a positive. And it's just knowing little interview techniques like that, just to keep calm. And again, that's what's being assessed. Will you be a good barrister or a good solicitor? And a lot of that is keeping your cool in pressured environments like interviews.
Brilliant. I think that's a great set of tips and probably a good place to leave things this week. Thank you so much for coming on the podcast.
Well, thank you for having me.
No worries at all.
That was really interesting. Thanks again to George for coming on. I really enjoyed hearing from a barrister who took such a unique route, taking the QLTT as opposed to the traditional pupillage route. I think we learned quite a lot today, the sort of advantages and disadvantages of being a solicitor or a barrister, how George picks up most of his work, sort of great advocacy tips as well, including not using sort of complicated jargon, the benefits of slowing down and taking your time and being as pleasant as possible during cross-examination, and making sure that you stand out in your pupillage application. So a shortish CV and cover letter, nice short concise summary on your CV, make sure you get the grades, and make sure you have the experience, make sure you've done your mini pupillages, make sure you've gone out and you've volunteered as well, and just padded out that CV. In the interview, make sure that you're aware that they will deliberately push you and put you under extreme pressure, so make sure you're prepared for that. Well, that's the end of the second episode of Life in Law. I hope you enjoyed listening, and we'll be sure to have more content out there soon. Thank you, take care.